everyone. Welcome to the Carlton Fields webinar on our 2024 class action survey. My name is Lauren Valdivia. I'm a shareholder in the Tampa office of Carlton Fields, where I practice employment and business litigation. I have varied experience in class actions, including particularly in labor and employment. I'm joined today on our webinar with two of my esteemed colleagues, Jack Clabby and Matt Allen. Jack is a co-director of the study of the survey, and he chairs our firm's securities litigation and enforcement practice. Jack represents financial services companies, insurance companies, and public companies in all manners of class action. Matt Allen, also co-director of the firm's class action survey, is chair of the class action practice group at Carlton Fields. And Matt has litigated dozens of class actions, in fact, just dozens of class actions in the last year alone. Our survey looks at best practices in reducing costs and managing risk in class action litigation. And this is our 13th year doing the survey. I'm going to have us move on to the next slide, which is our faces, moving on to the introduction and methodology. But let me first start out by giving you an agenda for the day. I'm first going to provide an overview of the methodology of the survey. From there, I'm going to turn it over to Jack, who will present the survey's findings and results before we dive down a little bit deeper on the findings and results. From there, Jack will pass the baton to Matt to discuss Supreme Court and circuit law on class actions, before I will then pick it back up with a section on some trends that we're seeing in the labor and employment arena. Matt will then jump back in and he'll talk about some additional cases and legal trends as it relates to AI class actions and the use of AI in class action defense. And finally, Jack will close us out by talking about best practices. There will be an opportunity for questions at the end. We certainly encourage this to be an interactive webinar, so please recognize that there is a Q&A function that you can register your questions, and we'll make every effort to get to those questions at the end. You're also free, obviously, to follow up after the webinar with any specific inquiries about any of the topics we discussed today. A few more housekeeping issues. We are requesting 1 hour of Florida, California, and Georgia CLE credit for this webinar. And then certainly you can apply in various jurisdictions with those credits. And we'll announce the code for you to use to apply for CLE in your state later on in the webinar. Last housekeeping matter, which is that we are in fact recording this webinar, as this slide in front of you says. It's being recorded for educational and training purposes. This recording may use and include questions and poll responses provided to you during the live event, and this recording will be made available after the conclusion of the live event and posted on our Carlton Fields website. So let's talk a little bit about the methodology, and maybe we can turn to the next slide here. Now, we created the survey in response to observations by in-house counsel that there's really a lack of quality research into best practices in reducing costs and mitigating risk in class action lawsuits. We are really, really proud of this survey. To our knowledge, this is the only survey of its kind, and we really designed the survey to be broad enough so that the results reported are meaningful and representative of what companies actually experience. We think the results provide relevant and insightful benchmarking information, particularly for in-house counsel. So the questions: who was interviewed? The 2024 survey, as with prior year surveys, is based on interviews with general counsel or senior legal officers at 332 Fortune 1000 and other large companies across 25 industries. And those industries included banking and financial services, consumer goods, energy, high tech, insurance, manufacturing, pharmaceuticals, professional services, and retail trade. The surveyed companies had an annual average revenue of $21.7 billion and a median annual revenue of $16.1 billion. And the next question is really, how were the interviews conducted? And it's Carlton Fields actually retained an independent consulting firm to select the companies and conduct the interviews. The consulting firm then provided back to us only aggregate data. Individual responses and company names were and are kept confidential. Turning to the next slide, I told you already that we're very proud of this survey, and we are. As I mentioned, this is the 13th year of the survey, and as years pass, we've gotten a lot of recognition for this survey, including by the media, the Chamber of Commerce, large companies, pure law firms, and even the late Justice Ginsburg of the Supreme Court. The slide on your screen shows some of that recognition. So now that I puffed our feathers a little bit, let's get to the subject matter. I'm going to turn it over to Jack Clabby, who will present this year's survey's findings.
Thank you. Let's go to the next slide. All right, so this shows a snapshot of the kinds of cases that in-house lawyers who work on class actions are facing. And so the big finding here is the growth in labor and employment as a percentage of the class actions. 4 out of 10 class actions now that are being faced by these large companies who we surveyed are labor and employment class actions. The survey respondents essentially pointed to employee activism and organization as sort of creating these pieces. Another big finding this year is almost a tripling of products liability cases as a percentage of the open cases. These are gross. I have some green arrows on these slides, not to show sort of ups or downs, but just to indicate where I'm talking about on the slides here. But really, this was the year where labor and employment essentially ate up all the other kinds of class actions as a percentage of the docket being faced by in-house lawyers. Really big growth. And consumer fraud dipped and technical statutory violations dipped, as well as insurance, to sort of give that ground to labor and employment. But this has really been the year where labor and employment sort of took over. Next slide. All right, so this slide presents the same data on the left-hand column that we were just looking at, but on the right-hand column, it contrasts it with the spending numbers. So overall last year, spending on class actions was $3.9 billion from companies, $3.9 billion. That's been up every year for the last 10 years. Right now, it's about 15% of all corporate legal spend is the defense of class actions. And what we're showing here is you can compare as a percentage of matters against a percentage of spending. And you can see, I guess, which are the cheaper to defend, which is not really the right way to phrase that, but that's really what this shows. The average labor and employment case as a percentage of the docket is less than a percentage of the budget. If you look at data privacy and cybersecurity and the securities class actions, that shows the comparably more expensive class actions. Part of that is that some of labor and employment, there can be efficiencies by bundling cases for the defense, or they're the type of cases that can occur, and there's maybe better playbooks for how to approach them, meaning as a percentage of the budget, it can be less, meaning you can defend it more efficiently. Next slide. All right, so this is a bit of a deep dive now, drill down into labor and employment. I mean, the interesting thing about labor and employment is that it's not like cost. It doesn't go up as a percentage of class actions every year. You can see from 2018 onward that it has fluctuated, dipping as far in 2021 down to about 47% of companies having faced them. So now with this lagging 5-year data we're showing on the screen, about 80%, so the vast majority of companies in the last 5 years have faced a labor and employment class action. So what that means is if you're not facing one and you're a large company or you work with large companies, either you're doing something really right, in which case share it with us, please, or you're going to face one, and you should think about what your strategy is going to be to tune up on it. But again, the growth of these labor and employment class actions is not inevitable, and it ebbs and it flows. This year, it's really flowing, as we mentioned across the last couple slides. All right, next slide, please. All right, so we've been talking about the snapshot of what's on the dockets. Let's talk about what's next. Next slide. All right, so this is a question where we ask the in-house attorneys, what's next, right? What do you expect the next several class actions for you to face will be? So not surprisingly, you see a large jump in labor and employment. You're seeing that, that reflects both what is presently on the docket, I think, as a predictor of what's coming next, but also for those companies maybe who haven't faced one in a little while. They're seeing what's out there in the legal press. They're seeing what's out there, what they're hearing from the human resources folks in their company, and they're getting ready for it now. Data privacy and consumer fraud more or less holding steady. Investment products is a really big dip here. This is something where if you look at, like, if you think about labor and employment against the average company, every company has employees, right? Some have a higher risk profile than others, but really this is, when you're looking at averages, investment products, that's a fairly substantial dip for them. And I think what this is showing is for even in-house attorneys at financial services companies, banks, insurance companies, life insurance companies, brokerages, they're seeing the risk as a labor and employment risk even for them, even if, seeing it not as an investment products case, which might be a specialization for them. And so I think this underscores that idea that preparing for labor and employment class actions, trying to control those risks is going to be really important to controlling costs and protecting your company for in-house lawyers. Next slide. All right, so this is asking the question a little bit differently, right? Which is, of the class actions that are coming, which ones pose the biggest risk? Okay, so this might not be which one is going to come next, but where do you see dollars out the door for your company? Labor and employment climbed a little bit. Data and privacy and cybersecurity also climbed, which is interesting because it went down as being the next wave, but the risks are sort of there that it's going to be there. But the finding here for labor and employment is important because this is showing that not just is it the next wave, but that the in-house attorneys are also calculating the risk differently. We'll see this on some other slides, how this moves through, but the labor and employment matters are getting more dangerous in addition to being a larger percentage of the time in the docket that's there. That's similar too for data privacy and cybersecurity. It's a large bump as a percentage, even though it's still only 11.8%. But there's been a lot of headlines about what they call hub and spoke data privacy actions, where there might be one software company that's shared by an entire industry. If something were to happen where data were exposed through that company, it would reflect a potential lawsuit against essentially every participant in the industry, causing more risk. Next slide. All right, this is a different way to slice up the same concept, where we asked in an open-ended way, what subject matters are posing the biggest risk for you? Far and away, with a big jump over last year, is this concept of growth in baseless claims. Some of these arise from consumer fraud, some of these arise from labor and employment, but the idea is that you might have some well-founded class actions or risky class actions in the industry, but then there might be follow-ons that are not, at least in the view of the in-house lawyers, as well-founded. And so this leads to a perception that the risk of handling not well-founded class actions is substantial. There was a big jump in ESG disclosure from 2022 to 2023, as some of the final rules got pushed through, culminating, I think, in the SEC's climate disclosure rule for public companies. So this is something that had a huge jump year over year as being seen as a source of risk. Social media being used for marketing. Again, this can premise consumer fraud, technical violations, even a products liability lawsuit, as well as labor and employment lawsuits. So the use by constituents, employees, customers of social media is seen as being a big risk. And for the first time this year, we saw a large jump, first time we even asked about it, to prompt the use of generative AI. Matt's going to talk about that in more detail later on here. But really what you're seeing here is a risk that is not always within the control of the lawyers who work on class actions for a company. It might be the consumer experience, the customer experience, user experience, the technology team, other parts of the company pushing to use generative AI without necessarily checking about litigation risks on it. And so I think we're going to see that number continuing to rise in the coming years. Let's go to the next slide. We always ask about settlements because, this is always an important data point when we think about what levers are there to control the expenses and the costs of class action litigation. And this year we had some surprising findings. Next slide. Matt's going to go into a little more detail on why we saw what we saw this year, but we essentially saw a lot less class action settlements than we've seen in previous years. Of the settlements that were had this year, a large percentage of them were individual settlements. As a result, the data on settlement terms reflects less use of creative terms than in years previous. This is a slide deck, I think, of all the things that we see for, in our practice, and we see Matt and I get questions on. This is one where we get a lot of questions because what's market is really important when you're thinking of what goes into a settlement, into a settlement agreement. And I think this was the year where we finally saw really the door shut on charitable contributions as a feature. Now, there's been some case law that questioned the use of charitable contributions in many class action settlements. But this year really continued the trend in the decline of its being used. Now, whether that case law is right or wrong, there's certainly a perception out there that it's going to be less as a part of this. This multiple types of release based on the circumstances. When this is lower, this tends to correlate with the settlement of less risky classes. What do we mean by that? So, if you're going to be settling a case with multiple forms of release, it tends to be a more complicated class action that's going to have higher administration costs. So if you're having a relatively lower dollar settlement, it tends to not support the use of these multiple tiers. Similarly, non-monetary compensation, when that's higher, that tends to correlate with the settlement of maybe cases that are perceived as being a little weaker, where there's going to be a payout of attorney's fees, and there's going to be a non-monetary compensation as a way of getting a case resolved that probably didn't have a lot of worth on the market. Now, there's exceptions to that, but that tends to be what we see when we report on this data. All right, at this point, let's go to the next slide, and I'll turn it over to Matt to talk about some of these Supreme Court cases and these trends in the context of the case law.
Thank you, Jack. First of all, this was a slow year in terms of Supreme Court cases addressing class action issues. Go ahead to the next slide, please. In fact, the only significant class action case to hit the Supreme Court was the Coinbase case. In that case, some users of Coinbase, an online currency platform, filed a class action against Coinbase for allegedly failing to replace funds that were fraudulently taken from the users' accounts. The Coinbase user agreement had an arbitration clause in it. So Coinbase predictably filed a motion to compel arbitration, which the district court denied, and Coinbase appealed. At the same time, Coinbase moved for a stay of proceedings in the district court pending resolution of its arbitration appeal. The district court denied the motion to stay, and the Ninth Circuit affirmed. The Supreme Court, however, reversed, holding that the district court has to stay its proceedings while an interlocutory appeal on the question of arbitrability is ongoing. Now, the decision was 5-4, and the majority reasoned that even though the text of the Federal Arbitration Act doesn't explicitly say whether a stay is required, Congress enacted the statute against a clear backdrop of Supreme Court precedent. And under that precedent, as a general matter, under what the court called the Griggs principle, an appeal divests the district court of jurisdiction over the issues involved in the appeal. Here, because the issue on appeal involved where the dispute would be resolved, effectively the entire case was involved in the appeal. Therefore, the appeal divested the district court of jurisdiction over the entire case. The court held this also made common sense. If a stay is allowed to proceed in court while an appeal, if the case is allowed rather, to proceed in court while an appeal over arbitrability is pending, all the benefits of arbitration, such as efficiency, less expense, less intrusive discovery, would be irretrievably lost. Next slide. Back to the survey for a second. So the survey showed that fewer companies are doing what Coinbase did and putting mandatory arbitration provisions in their contracts. 41% of companies are reporting they don't use mandatory arbitration agreements, up from 29.4% last year. Surprisingly, at least to me, 21% of companies don't preclude class arbitration in their arbitration agreements. Next slide. Even more surprisingly, at least to me, only 35% of companies put in their arbitration agreements class action waivers, that is, prohibitions on class actions in court, as opposed to class arbitration, which the last slide addressed. Companies report that perceived regulatory resistance and concerns about consumer reaction drive them to omit class action waivers. I also wonder whether some of this reluctance on the part of companies to use class action waivers and prohibitions of class arbitration stem from recent publicity over the dangers of mass arbitration. This is something we added to the survey last year and reported on in last year's webinar. Next slide, please. You probably know that mass arbitration occurs when a company faces a series of hundreds or even thousands of nearly identical single claimant arbitrations. A coordinating plaintiffs' counsel usually files all these claims, and when this is done at a large scale, the company defending the arbitrations typically has a clause in its arbitration contract that says it will pay the cost of arbitration. So when that's the case, you can imagine the pressure on the company to settle because of the large amount of filing fees the company will have to pay. And to make matters worse, in some states, such as California, the fee has to be paid within 30 days of the due date to avoid sanctions for failure to pay. There are some horror stories in this regard. Uber, for example, unsuccessfully sued the American Arbitration Association over excessive administrative fees in mass actions when it had to pay $91 million in fees to initiate 31,000 pending cases against it. Other companies facing recent mass arbitrations include Amazon, DoorDash, Postmates, and Intuit. Despite the flashy headlines, though, the survey reports that only 5.9% of companies have faced mass arbitrations. This is a modest increase over last year's report of 3.9%. So it's not a trend, at least not yet anyway. I want to report on 3 more developments before turning it over to Lauren to talk about labor and employment class actions some more. The first relates to standing. Next slide, please. The survey predictably identified failure to state a claim and absence of commonality and predominance as the most successful class action defenses. That's pretty basic, right? Last year, though, we noted a new trend is emerging, defending class actions on the basis of lack of an actual injury. One example of that is the Sixth Circuit's decision in the DuPont case, personal injury litigation case. We talked about this in last year's webinar when the appeal before the Sixth Circuit was still pending. So in that case, an Ohio district court certified a class of Ohio residents under Rule 23b-2. The plaintiff alleged that nearly all Americans have a group of what they call forever chemicals, such as PFAS, in their blood, and that exposure to PFAS may increase the risk of developing cancer. PFAS doesn't exist in nature, but was put into large-scale manufacturing and use starting in the 1930s. In the lawsuit, the plaintiff sought an injunction ordering 3M, DuPont, and other manufacturers to fund what they called a science panel to study the effects of PFAS and potentially provide medical monitoring for every member of the class. The district court certified a class of every individual subject to the laws of Ohio whose blood contained 0.05 parts per trillion of PFAS, or nearly all 11.8 million residents of Ohio. The Sixth Circuit concluded that the named plaintiff lacked standing, obviously reversing, because he failed to show that his injury was traceable to each of the 10 defendants. He was required to tie his alleged injury to each defendant, and he couldn't simply lump them together in his allegations, even though that's exactly what he did in the complaint. The plaintiff also couldn't show that any of the defendants manufactured the 5 compounds found in his blood, so the court ordered the case dismissed for lack of jurisdiction. Next slide, please. Now, as the next 2 slides show, the survey reports the number of class action settlements overall were down to the lowest level in 6 years, from 47% in 2022 to 25% in 2023. Next slide. The survey also reports that individual settlements were up, this time from 46% in 2022 to 77% in 2023. It remains to be seen whether this statistic is an anomaly. It may be that companies are adopting a 2-pronged approach. First, try to settle claims early on in an individual, essentially nuisance value settlement, and then failing that to vigorously oppose class certification in the merits. That said, there were some large class action settlements this year. 3M agreed to pay $12.5 billion to resolve claims that polluted drinking water supplies using the so-called forever chemicals such as PFAS. The settlement was approved by a South Carolina court last month. In a separate case, 3M also paid $6 billion with a B to settle lawsuits alleging that ineffective earplugs failed to protect veterans from hearing loss. In March, the Second Circuit approved a $5.6 billion antitrust class action settlement with more than 12 million retailers alleging Visa and MasterCard improperly set credit and debit card fees. And then, case most people know about, the National Association of Realtors agreed to pay $418 million to resolve an antitrust class action over how buyer broker commissions are set. And just last week, a Missouri judge approved a preliminary approval of that settlement. Finally, last year, we reported on a split in the circuits on how to deal with incentive fees in settlements. It's a common practice for companies settling class actions on a class-wide basis to agree to pay a service fee or incentive award to the class representative. The amount can range from a few $100s to a few $1,000s. And in my experience, defendants don't like to pay these fees, but they recognize that doing so is sometimes a practical cost of obtaining a settlement. Most circuits allow and approve the use of these incentive fees to the named plaintiff. The 11th Circuit does not. And a recent Second Circuit decision, Fikes Wholesale versus HSBC Bank, also called their use dubious. In two cases this last term, Johnson versus Dickinson and Dickinson versus Johnson, the Supreme Court denied cert and refused to resolve the split. So in the 11th Circuit, and perhaps the Second Circuit, at least arguably, the class representatives cannot be awarded incentive fees. In other circuits, they can. Now, I'm in Florida, which is part of the 11th Circuit. In my experience, this prohibition hasn't stopped plaintiffs' attorneys from filing class actions in 11th Circuit district courts. I'll turn it back over now to Laura to talk about labor and employment.
Thanks, Matt. So you've already heard from Jack that labor and employment class actions jumped approximately at 10% in the last year. Just to give you an idea of the numbers here, this study reported in 2020 that labor and employment class actions comprised 22.5% of class actions against survey respondents. That number increased in 2021 to 25.6%. It increased again in 2022 to 33.6%. And now, as Jack indicated, in the last year, it's a whopping 43.4% of class actions filed against survey respondents. So this is certainly an area that we're seeing an increase in, and frankly, that we anticipate we may continue to see an increase in. And the litigation spend and costs are reflective of those increased percentages as well. Survey respondents, as Jack indicated, reported that their highest defense spend is in fact on labor employment class actions in the class action arena. Next slide. So let's talk about what types of actions we're typically seeing in this arena and what companies are currently facing. Some of these are really not new. Wage and hour certainly has always been at the top of everyone's list, and it continues to be so. We're also seeing ERISA class actions, discrimination class actions, and AI data privacy class actions. Turning to the next slide, why are companies seeing such a stark increase in labor and employment class actions? Turning to the next slide, our survey respondents gave us their thoughts, and there were a number of things that stood out that we've also had an opportunity to roundtable a little bit internally. First and foremost, we're just seeing an increase in workplace activism. And part of that is that we understand that we're seeing the highest level of unionization efforts in history right now. Private sector unionization rose by more than 250,000 employees in 2023, and specifically in 2023, 16.2 million workers were represented by a union. I think we're going to see that number continue to increase. There is still an impact from COVID-19, from the pandemic. We are still seeing a little bit of the reverb from COVID-19, and it's particularly true as it relates to hybrid work policies. That is something that it appears is here to stay. And part of that, obviously, is employees seeking additional flexibility in their work schedule. And so a lot of companies have adopted hybrid work policies. Perhaps it was fully remote during COVID or hybrid during COVID, but we're seeing that these policies are here to stay and that there is an increase in litigation as a result. There's also an increased dissatisfaction with pay. We're seeing wage and hour suits, which have always been relatively high, continuing to increase. And I'm sure I'm not surprising anyone with that news, but certainly many employees feel that there is a significant gap between wage growth and inflation. And between that sentiment and other factors, we continue to see an increase in wage and hour suits. Within the labor and employment class action arena, sort of narrowing it down even further, the largest number of class certifications are suits alleging violations of the FLSA or state law corollaries. And last but not least, we are seeing an increase in discrimination suits. And the EEOC nearly doubled the number of suits that it filed in 2023, with the majority falling under Title VII. In 2023 alone, the EEOC filed 25 systemic discrimination lawsuits, and that number is essentially double the amount of suits they had filed in years prior. Under the same category, we really can't omit the potential significance of the U.S. Supreme Court's decision in the handful of affirmative action cases that came out last year. We know that the Supreme Court essentially dismantled affirmative action and higher education, and we're still trying to work through what that looks like in the employment setting, particularly as it relates to corporate DE&I efforts, DE&I being representative, of course, of diversity, equity, and inclusion. So turning to the next slide, what are some common proactive steps and defenses an employer can take to stem the tide of labor and employment class actions? Next slide. We have a couple of suggestions here, and certainly I'm sure there are more, and I welcome anyone putting any suggestions or ideas of their own in the chat. But under the wage and hour arena, we are suggesting, and survey respondents have also included their thoughts as to auditing policies, practices, and procedures, and conducting these pay audits, especially when we're thinking about issues like pay equity. There's also a suggestion of ensuring that there's written overtime procedures, ensuring that there are procedures in place, and then last but not least, ensuring that employees are being trained in this arena, and that training includes all levels of employees, including supervisors, to best ensure adherence to your own policies. In the ERISA arena, I actually contacted and consulted my colleague, Gina Alsdorf, who's a shareholder in our DC office, because ERISA is not really my area of expertise. I picked her brain for a while, and she notified me of several new novel theories in ERISA suits right now, including healthcare plans and their use of pharmaceutical benefits managers being challenged for unreasonable fees. She also referenced pension risk transfers being attacked as imprudent. And essentially the guidance here, the suggestion here, is implementing a committee for oversight and for monitoring. As it relates to discrimination suits, it really comes down to scrutinizing all existing policies, and that's particularly true for DE&I policies and practices, given the Supreme Court's decision as it relates to affirmative action. Like the infamous Carnegie Hall joke, how do you get to Carnegie Hall? Practice, practice, practice. We talk about discrimination suits. How do you avoid discrimination suits or claims of discrimination? Among other things, training, training, training. So that's a frequent refrain that we say that we've talked about in this arena. And last but not least, AI and data privacy, which Matt's going to talk a little bit more fulsome on AI and data privacy, but essentially auditing and testing software and algorithms and really ensuring transparency and policies. Employers really need to consider having privacy policies for how they collect, store, and then use employee information. Turning to the next slide, the last proactive step we certainly thought was worthy of its own slide, which is really arbitration agreements. Turning to the next slide, the survey concluded that relatively few companies are using arbitration agreements currently. And even fewer are using class action waivers within their employment agreements. We have received several responses regarding the decision not to use or to move away from arbitration agreements. Obviously, certain jurisdictions have banned them, and there's increased regulatory scrutiny in this arena, but there is certainly a benefit to the use of arbitration agreements, particularly in jurisdictions that permit them. Matt, I saw you unmuted. Did you have a thought?
No, keep going.
Okay. Okay. So with that being said, arbitration agreements are still certainly a tool that are useful and effective. They're, despite the fact that there is increased regulatory scrutiny and that certain jurisdictions have banned them, and frankly, that there is employee workplace activism against such types of agreements, they are still permitted in certain jurisdictions, and we still find them to be useful in that context. So with that being said, I'm going to turn it over now to Jack, who is going to pick up on the next section.
Actually, it's back to me, Lauren.
Apologies, Matt.
No problem. So I want to spend just a few minutes now talking about what's quickly become a hot button issue, artificial intelligence and class actions. With the relatively recent advent of generative AI, there has been an explosion of discussion in this area. Next slide, please. There are some interesting findings about artificial intelligence in the survey. In a nutshell, companies are both worried about it and at the same time, they want their outside lawyers to use it. Companies are worried about it because generative AI is leading to some interesting lawsuits. The chief concern is over data privacy and the unintended release of sensitive data. Are users' input data being collected? How is it being stored? How is it being reviewed? And these concerns are important, but the types of concerns expressed by respondents definitely go beyond just data privacy. So intellectual property is a concern because generative AI models that draw on massive quantities of data don't always differentiate between protected and unprotected source material. Let me give you just 3 examples of cases that have already been filed. The first involves data privacy. In Doe 1 versus GitHub Inc., some software developers sued GitHub in the Northern District of California over its development of 2 coding tools, Copilot and Codex, that allegedly improperly used the plaintiff's sensitive personal data by incorporating it into the tools and then selling it to third parties. The case was dismissed because the plaintiffs couldn't show any specific disclosure of their personal information. Of course, but what if they could have? The second case involves copyright concerns. In Anderson versus Stability AI Limited, 3 artists alleged that Stability AI scraped copyright images from the internet without permission to train its Stable Diffusion product to produce output images in the style of particular artists without attribution to their original source. This complaint was also filed in the Northern District of California, and for the most part, it survived a motion to dismiss. Now, I want to mention a third case involving consumer misrepresentation concerns. This is not a class action, but it struck my interest because Air Canada recently had a judgment entered against it in a suit by a passenger who booked a ticket on a flight based on a representation by an airline chatbot that he could get a partial refund if certain conditions occurred. That representation turned out to be wrong. Now, the judgment was only an individual judgment, but what if the chatbot had said the same thing to 100 or 1,000 passengers and they too relied on it to buy their tickets? You get my point. Seems like a possible class action to me. The risks are substantial. And so the bottom line is if your company is using or exploring using generative AI, and I get what Jack said earlier, that sometimes this is outside the control of the legal department, make sure you understand the risks. The simple fact is the more companies use it, the more they will become targets for class actions. Next slide, please. Now, 61% of companies want their outside lawyers to use generative AI because they believe it will control costs. At the same time, a healthy minority, 26.5%, are of the strongly held view that outside firms should not use generative AI because of unknown risks and unproven results. We're all familiar, I'm sure, with cases in which lawyers were sanctioned for using ChatGPT to create briefs which the lawyers submitted without checking the results. But critics note that this is just the tip of the spear, and they argue that unreliability is both a feature and a bug. This is because large language model generative AI doesn't think. It digests a huge amount of text and predicts what a human most likely would say in response to questions, limited, of course, by the way the question is framed. But the important thing to understand is that the prediction is not tethered by fact, it's an algorithm. As my partner Peter Winders has written in an article for Bloomberg, he said, we have no way to determine what the tool saw, what it missed, what it overlooked, what it misunderstood, the analogies it failed to make, what authorities were truly supported or adverse based on a nuanced understanding of the facts of our own case and the facts of decided cases, what policies animated those cases, or what lines of analysis might have been left out of the query used for the search. All I'm saying is companies and law firms who contemplate using generative AI in the legal field need to grapple with these concerns. Next slide, please. Despite the risks, almost 2/3 of corporate counsel hope that outside counsel can use generative AI in some way to lower defense costs. And yet, about 24%, again, a healthy minority, are skeptical of any noticeable changes or impacts on costs as a result of outside law firms using generative AI. Next slide. I wrote an article for Law 360 about this tension that was published last month. My law partner and our firm's general counsel, Peter Winders, has also written an article that I already quoted about the risks of generative AI in the law firm context. We're not going to solve the debate over the use of generative AI in the legal profession in this webinar. I think the most we can say at this point is that the debate underscores a deeper concern about how to control the growing costs of defending class actions. So Jack Clabby is going to close us out by talking about this broader issue of how companies are trying to control the costs of defense. Jack, back to you.
Yeah, thanks, Matt. Let's go to the next slide. I think that pivot on AI makes it, I think that's where it all fits in together, is how can, the survey has a very strong result that there's distrust around AI and worry that it's going to prompt class actions for their own use of it. At the same time, those same lawyers want outside counsel to explore its use in lowering the cost and helping defend them. And I think that's exactly right, Matt, that the cost that grows each of the last 10 years in defending class actions, more and more cases are being put on in-house dockets. Anything that could potentially save costs is something worth exploring. So when we talk about these survey results now, we're going to talk about things, including technology, that can help lower those costs, or that are reported to us as doing it in real time, in real life, as opposed to what could happen down the road if AI pans out. So let's go to the next slide. All right, so this here we ask in-house lawyers, what's your approach? Sort of an open-ended, what's your approach to managing your class action docket? And there were some big changes from last year. Last year, there was a 43% said we do early case assessment, right? We're going to invest chunk of money up front, and we're going to see based on that investment whether it's going to be a motion to dismiss, whether it's going to be answer and defeat class cert, or settle quickly, right? That number dropped, and it was essentially replaced with get out quickly. We think where this comes from is, if you have an experienced lawyer working with experienced outside counsel and a new case comes in, you don't need to do an early case assessment if you have a pretty good sense of where it's going to go. Think about a labor and employment case where it might be the second one the company's had in as many years, and they have a pretty good sense of what their employment practices are for doing that first case. There, you don't need to do as fulsome an early case assessment. Instead, you might look into an individualized settlement. We think, for example, that that's what happened that drives a lot of this data from 2023. You see that get out quickly. That reflects really two things. One, frivolous lawsuits that can be resolved quickly with individual settlements. And two, repetitive lawsuits that might have some ground where the company has a pretty good sense of its practices and therefore can structure a resolution without having to undergo a complete early case assessment. About 1 in 4, and these are the ones that are a lot of fun to work with, but can be expensive. Be aggressive. There's always going to be 1 in 4. I think that's about what that number is, what we've seen over the last several years of doing this survey. What do we make of the dip in retaining trusted outside counsel? I'm not sure that that means that people don't trust their outside counsel anymore. I think it just means that the approach shifts from giving it over to counsel and letting them sort of figure out what to do versus retaining more control on the part of the in-house lawyers who now have more experience, are spending more time on class actions than in the past 3 years, and have hired more headcount, as we'll show in a minute, to help manage these things. So I think that's not showing a distrust in outside counsel, but instead I think it's in-house lawyers taking more control over the fate of the class action docket. Next slide, please. All right, we asked the question now a little bit differently, which is, in your view, what is the unwritten secret to beating a class action? We got some interesting results this year, too. You can see this settle as soon as it makes sense. This is, I think, an increase, but it's also sort of 1 in 4 now saying that this is their secret to doing it. So I think this is the funnel that includes both the sort of frivolous class actions and the class actions that are non-frivolous but well-known or the law is well-developed around them, so the case assessment can be done relatively quickly without a big spend. Filing a strong motion to dismiss. Now, we have reported on this as being an effective strategy. What's the difference here? I think what this really means is, if you were to ask what is the unwritten, one, it's not a secret, a motion to dismiss. But two, I think there's a skepticism on the part of in-house lawyers as well as defense attorneys that you can't always rely on a strong motion to dismiss, a motion to dismiss, even if it's strong, to guarantee you a dismissal. That's particularly true with the perceived difference between, say, a state court and a federal court in the pleading standard. Additionally, as we saw, about 50% of every class action is a consumer fraud class action or a labor and employment class action. The pleading standards in those cases are well known. There's well-developed, smart plaintiffs' lawyers who are bringing these cases. And in many of them, they know how to plead a case to get around a strong motion to dismiss. And so that becomes not really the default path in every case. So rather than default to a strong motion to dismiss, think through whether it's worth it to file it, particularly in a case that is one of these repetitive topic class actions where the pleading standards generally well known. That's different, of course, if you're in more of a one-off world or a world where there's a heightened pleading standard like securities fraud class actions or standing cases where you might have a 12b1 motion, such as a data security class action. Next slide. All right, also some big changes here. When we ask folks, what's your approach to managing that next wave, right? So this isn't asking them about what their current docket is and how they've been successful in managing it. This is saying, for what's coming, what do you do? Here we've got a couple of big findings, but I think this real big jump in proactively mitigating risk, this is sort of that counterpoint to what we discussed earlier about AI and chatbots being deployed without checking with the in-house class action lawyers. Here, I think the increase in time that in-house lawyers are spending on class actions, an increase in headcount, and an increase in budget comes with an increase in the ability to effectuate change outside of individual cases. So this is saying about 50% of our respondents said that they're adopting an approach where they can proactively mitigate risk. This is great news, right? It tells us a couple of things. One, you've got an increased in terms of the profile of the in-house lawyers in terms of getting things done. And two, they're increasing the in-house resources where they can actually have time to do proactive mitigation, not just responding to things. I also think that hiring specialists and outside consultants saw a pretty big jump. This is something we've seen to evolve over the last few years. Anecdotally, what this can mean is hiring consultants to work on business practices that are often challenged. Things like social media use by employees, social media use by marketing teams, as well as general human resources consulting to make sure that you're doing things right. Also, what Lauren mentioned a little bit ago, involving outside counsel in audits, but you can also involve specialists who are HR specialists to look at particular issues that you might have that could premise a labor and employment class action. And finally, we're pumping our fists at this one, but using arbitration agreements, tripling. That's really big news. We've been getting excited about this more and more. And this is the sort of thing where, if there is something that can really stop a class action, this is it. And to the extent it works for your company, it's worth exploring. All right, next slide. All right, so what are we talking about when I've been saying the growth in in-house resources? Next slide. All right, so it's more cases than ever. And you can see that what's been projected for 2024 is even more of an increase. But for 2023, you're seeing 5.3 new matters, right? So that's the most amount of new matters in our survey's history that were filed in 2023 against this cohort of companies. And you also saw a projected carryover for those, meaning those are not getting closed out within 2023 and they got pulled into 2024. So you're seeing more cases, including cases that were not resolved in the carryover. Next slide. The response of companies has been to spend a little bit more time on it per lawyer, but also to do some hiring. So look at this jump from 2022, you had the rough average of 3.3 lawyers handling it, but now you've got 4.7 rough full-time equivalent lawyers dedicated to class actions. This is a big jump, and it's the highest number that we've measured in the survey's history. This is good news for a lot of things, particularly about managing cost and having better outcomes. And I think that in-house attorneys, when they know class actions and they know their companies, can work more effectively to defend those companies and can work more effectively with outside counsel and more efficiently. All right, next slide. All right, insurance is something we've been asking about now for many years. And this slide shows, I think, an increase in the companies that have defense costs for class actions that were covered by some insurance policy. All right, and labor and employment might represent a nice chunk of this if there's an EPL policy or other policy responding to those lawsuits. But you see it inching up from 2021, more than inching up, right? But going up about 20% over the last 2 years. At the same time, you see the actual percentage of the costs going down. So probably what this tells us is that, that there's probably high self-insured retentions that are going on here where maybe the policy isn't kicking in early, and that reflects a conversation that companies are having with their brokers. But given that our advice kind of coming out of this is to take the page from our class action survey about the coming wave of class actions, have a conversation with your broker about what potential defenses and what potential response there might be from your insurance program, and see if you might work in additional protections for labor and employment, for consumer fraud, and for data privacy and security. All right, next slide. All right, so let's talk about what the reported practices are that can reduce costs, what's seen as effective from the in-house lawyers that we talked about. Next slide. All right, so what we're seeing here is high-risk matters inching up and lower exposure matters sort of inching down. There's been some changes in complex and bet the company, but not really a trend. I think what we're seeing here is the types of lawsuits that are taking up a higher percentage of the docket tend to be the kind you can't get rid of with a straightforward motion to dismiss, and so they're not really seen as lower exposure. Similarly, to the extent that the class, labor and employment action or a consumer action can be seen to be all or many of the employees of a company or all or many of the consumers, it's hard to categorize those as lower exposure. And so as those two types of class actions take over a bigger chunk, you're seeing more being classified as complex and more being classified as high risk. I think that's the story that is being told by this data. The lower exposure matters tend to be the sort of relatively low dollar technical statutory violations, like maybe a TCPA class action or even a Video Privacy Protection Act class action, where there might be a reasonable cost that can be assigned to it, and it doesn't necessarily cover the entire business practices of a company. All right, let's go to the next slide. All right, and how are they staffing these matters? I mean, what we saw this year from last year is that it was moving in two different directions. You saw the overall number of law firms that the large companies we surveyed using went down dramatically from about 53 to about 44. So that's a pretty big drop. Similarly, you're seeing, conversely, you're seeing a jump by half a law firm in the average number of law firms handling class actions. And so if we saw an expansion in the number of class actions, you didn't see those necessarily being handled by the existing law firms, but by having new law firm talent being brought in. So even as the overall law firms that are used goes down for all matters, we saw a jump in the amount of class action law firms that were used by the same companies. Next slide. All right, so what works here? Using trusted outside counsel still remains the core of it, because from that trust can come trade-offs, honest conversations about efficiencies, and experimentation too with some of the AFAs. But really what we're seeing is a jump in settlement. And that is consistent with the theme we've been talking about over our time together this afternoon, is that a frivolous case or a case that is not frivolous, but the parameters of the risk are well known, can be often settled early, either with a nuisance value for cost of defense or for more principled value within a well-known set of values. Reducing the number of law firms here, this is something that has grown in the 2 years that we're sort of showing up here. You're really seeing this as being an opportunity to control costs. So if you're using a number of them, cutting down on them could be a way of saving costs. Now, that's a little different than the data we were reporting on the growth overall. But remember, if the number of cases is increasing, you can still increase the number of law firms in a slower way, and you're still sort of getting a cost savings potentially by bundling those things. Next slide. These are some of the other sort of big jumps. You see asking it a different way when we talk about bundling sees a fair amount of success. You're essentially training the outside law firms to be more efficient in the subject matters and in your own business. Limiting the outside counsel staffing saw a big jump too. This has long been reported as sort of a secret by in-house lawyers, but it's the same principle as bundling. You're training a specific set of lawyers, right? It might be a partner and 2 associates, or 2 partners and 3 associates for a big one. But what you're doing is you're training a team to work with your people directly to do a better job and a more efficient job. Now, the kind of flip side to that is if it's a busy team, are you getting the work product done in a quick way? If not, maybe you bring in another attorney, or you bring in another law firm to sort of help with it. Adopting new technology actually went down, which is a little bit of a surprise, but on average, it's still up from where it was in 2022. This one, look, if AI pans out as being a real cost controlling mechanism for this, we'll see that probably increase. And using AFAs, which is sort of our pivot point for our last topic, is going down even more. And I think AFAs are being seen by in-house lawyers as just being too much work to do successfully, a point we'll push back on. Next slide. I think the real kind of core here is that probably 1 out of 4 law firms, 1 out of 4 in-house lawyers is using law firms in a supervisory role. This is particularly effective in, say, a products suit where you've got one product where there's litigation in multiple jurisdictions. You sort of assign one company to really learn it, one law firm to learn it really well, and then teach regional experts on the courts how to do it, and it works in a highly effective way. All right, next slide. We'll wrap up on AFAs, and we're going to see a trend continuing from last year's survey. Next slide. You're really seeing fatigue and a bit of a market rejection of AFAs. And I don't know who bears the blame here. I think it's probably outside lawyers not slowing down and being creative in what they propose, but it's also in-house lawyers who are busy or maybe were burned on a prior AFA being more reluctant to use them. But this is simply the use of them, not their success, which is a little bit depressing for proponents like we are of AFAs. Next slide. All right. There's one ring to rule them all. The king of the AFA is the phase payment. This is where you come up with a number for each section: early case assessment, motion to dismiss, pre-class discovery, class cert, expert work, where you're setting the phases before they begin. So you're getting smarter and smarter as the case goes on as to what things will cost. This is a smarter way of doing flat fees, which had a dramatic drop in success rates from even last year when it was still relatively low. So I think the future of the flat fee model is by doing it in phases rather than by trying to set one number at the outset of a case. There's still a place for it in repetitive class actions, but I think it's less and less popular as it goes on. Blended rates took a jump, and I think that's because blended rates are really easy to administer. You simply say the partners and the associates will all bill at one rate. The partner takes a haircut, maybe the associates get a little bump, and there's a lot of cost savings that can be had from there. All right, let's take a look at the next slide. We asked this question straight up because a lot of our clients last year sort of gave this as an issue. And it's kind of exciting, but what about success fees? And this is, I think, a large number. 15% are using success fees for class action defense. This is really creative and can really spread out some of the risk of class actions between the in-house lawyer and the outside lawyer. You need a lot of trust to accomplish it, though. I think we've answered the questions that came in through the chat, but of course, if you have any questions, we'd be happy to answer them now. You can just throw any additional questions you have in the chat. Of course, if you want to talk more about this survey, or if you have another perspective on interpretation, we love this, right? This is the kind of conversation that Matt and Lauren and I would be having, even if we were having lunch together in person. So we're glad you got to join us. So please do reach out to us if you want to talk about any of this stuff. If you want to talk about ways you can save money in defending class actions or techniques and tricks that we've seen from our survey respondents that could be helpful to you in your practice or for your company. I don't think we have any additional questions coming through. So on behalf of Carlton Fields and Matt and Lauren, I want to say thank you all for joining us. And I hope you have a great rest of your day. Thanks so much, everyone.
Thank you.